Hello and welcome. Today I'm going to talk about how foreign investors can form a company in Russia. In general, the procedure is not very difficult. However, certain aspects depend on what the corporate form will be, how many founders there are, and what the status of the founders is, whether they are individuals or corporations. The finer points are more numerous if the founders are foreign investors. If these finer points are not taken into account, your business can suffer serious problems, such as company registration being denied, following which you need to correct mistakes and restart the procedure. This may mean that you fail to meet the project deadlines, lose a contract with an important partner, and see costs increase. Also, after a company has been registered, mistakes can result in administrative liability being imposed on a foreign director or the company itself, and in significant fines, even to the point of the company's activity being suspended. I will cover this in more detail later. So then, today I'm going to talk about how a foreign investor can form a company in Russia using the example of an LLC, a Limited Liability Company, the most widespread corporate form. We will consider the following: general preparation, the set of documents, the procedure and timeframes. First, you need to decide what your primary parameters will be. First, the composition of the founders. You can have one or several founders, only foreign investors, or a blend of foreign and Russian ones, and individuals or companies. Second, the corporate form, an LLC or a joint stock company, and the name of the company. There are certain intricacies. For example, you cannot use names of foreign states and derivatives in the name of your company. For example, the name of your company may not include the words China or Chinese, and the words Russia and Russian can be used only with the permission of the Russian Ministry of Justice. The name, the primary name, should be in Russian. You can select an additional version in a foreign language. Third, the place of business and address. The address of a legal entity is understood to be the address of its chief executive officer, in other words, the address where the company operates. You can, for example, lease a facility or purchase it after your company is registered. We recommend avoiding mass registration addresses because they may cause the registration of the company to be denied. You can check an address using the Russian Federal Tax Service's Transparent Business Service. There are more aspects you should take into account. For example, if you plan to become a resident of an investment regime with tax benefits, such as an advanced development area, in order to be able to enjoy tax benefits and preferences, you need to select an address within the borders of this advanced development area. Fourth, types of activity. Select as the primary type of activity the one from which you plan to be receiving the bulk of your income. All other activities should be supplemental. Then you need to select the appropriate codes under the all-Russian classification of types of economic activities, which will be entered into the company's register, the Unified State Register of Legal Entities. You need to keep in mind that you can carry out certain types of activity only if you have a license or permit. Fifth, the amount of the issued capital and the procedure for paying it up. There is a requirement for the minimum amount of the issued capital. In standard cases, for an LLC it is 10,000 rubles, and for certain types of business the amount is greater. It can be paid up in money or with non-money assets, but only after the company has been registered. Sixth, management bodies and, most importantly, the chief executive officer. For example, your company can have one or several directors acting jointly or independently and having the same or different powers. In our practice, we often receive requests from foreign investors to appoint a foreign national as CEO from the very beginning, when the company is being formed. However, the CEO, General Director, is an employee. If Chinese national doesn't have a Russian temporary or permanent residence permit, the company needs to obtain a work permit for this individual as a foreign employee. This may be done after the company has been registered. The absence of the work permit will not affect the registration process, but administrative liability for violating employment legislation in the absence of a work permit is very serious, even to the point of the company's activity being suspended, as I have mentioned at the beginning of my presentation. It is advisable to start off by appointing a Russian national to the position of the general director of the company being formed, then to form a company, obtain the permission documents for the foreign employee, and then to change the general director. Now, having dealt with the main parameters, we can start preparing the set of documents. There is a list of the required documents that must be submitted to the registration authority, the tax inspectorate. Also, there are documents that are required when a company is being formed or to confirm the powers of the chief executive officer of a corporate founder when the application is signed for the state registration of a company. Let us look at the documents that a foreign investor usually provides. If a founder is a foreign company, these documents include an extract from the foreign company register, or another document that confirms the legal status of the founder, the articles of association of the corporate founder, minutes, or a resolution to appoint the corporate founder's CEO. We had a situation in our practice when two documents were required because, according to the constituent documents, the CEO was appointed by the board of directors, and this appointment had to be approved at the level of the general meetings of shareholders. Then, the passport of the corporate founder's CEO. More documents may be required, but it depends on the content of the constituent document of the corporate founder. Please note that all official documents issued by foreign authorities and copies of corporate documents certified by a foreign notary must be apostilled or legalized. In November 2023, China ratified the Hague Convention, which cancels the requirement for foreign official documents to be legalized. Now an apostille is sufficient. Also, all documents drafted in a foreign language, in this case in Chinese, need a certified translation into Russian. The translation can be certified by a Russian notary or by a Russian consulate in China. If the founder is a foreign individual and not a company, the individual's passport is required, a notarized copy with a certified translation into Russian. Let us consider documents that Russian lawyers usually draft or fill in: a resolution, minutes, to form the company, an application for the state registration of the company, the charter of the company that is being formed, and there are two options possible for the charter: a charter prepared independently, or one of the 36 standard form charters of an LLC can be selected. In this case, the number of the standard form charters should be specified in the application for state registration. You can select these on the tax inspectorate's website. Based on your preferences, you can select the most suitable charter. The advantages of preparing an independent charter include the possibility of having an executive body with multiple members, for example, two appointed directors acting jointly or independently, an extended list of matters and categories of transactions that require the founder's consent, an increased number of votes required for a corporate consent, and more. On the other hand, using a standard form charter is convenient because there is no need to amend the charter and to register the amendments if the company's name or place of business changes, moves to another region. Other documents that will be required are a letter of guarantee from the owner of the premises or the building to confirm that the address can be used to register the company, and a receipt of the payment of the state duty of 4,000 rubles. However, there is no need to pay the state duty if the application for state registration and the set of documents are filed in electronic form, for example, through a notary. More about this later. Also, if there is more than one founder, an agreement to form the LLC will be required. It determines how the founders work together to form the company, the amount of the issued capital, and how each founder's membership interest should be paid for and by what due dates. Despite such agreement being mandatory, when there is more than one founder, there is no need to provide it for registration. As an option, the founders may conclude a corporate agreement to agree the voting options at the general meeting of members, include a clause concerning the sale of a membership interest in certain circumstances. For instance, in a deadlock situation, when the founders are unable to reach a decision together and the stalemate brings progress to a halt, or when other issues arise in connection with the shareholders' rights. This document is not required for registration and can be concluded at a later stage. Let us also consider the procedure and time frames. In practice, the easiest way for foreign founders is to file the documents for registration through a Russian notary. The chief executive officer of a corporate founder or an individual founder must sign an application for state registration in the notary's presence. The notary will confirm this person's identity and the powers to act on behalf of the corporate founder. At the same time, if the chief executive officer of a corporate founder or an individual founder is a foreign national and doesn't know Russian, a translator must accompany them. Then the notary forwards the application and the required documents to the tax authority. The tax authority considers the documents for 3 business days and sends information that the company has been registered. The result of state registration may be sent to an email address specified in the application. If you wish, you can also receive hard copy versions of the documents. Now your company has been formed. However, for it to launch its operation, many other problems need to be solved. Have the seal made, if it is resolved that a seal is necessary, and this may be done at a later stage. Open a settlement account with the bank, pay up the issued capital within 4 months after the company is registered, obtain licenses and permits, formalize employment relationships, including with the CEO, and more. The entire procedure can take up to 2.5 months, including having documents prepared and issued. Please note that if the company requires any permits or prior approvals for it to be formed, for example from the Antitrust Authority or the Government Commission on Monitoring Foreign Investment, these must be obtained before documents are submitted for registration. Finally, I would like to point out that the only difference in forming a company that would operate under a preferential regime, such as in an advanced development area, or ADA, is that you need to select the specific ADA in advance, check that land plots are available, and obtain the prior agreement of the management company, which will afterwards grant the status of a resident of the ADA. Such management company needs to confirm that this address is within the ADA's borders. Well, today I've spoken to you about the main stages of forming a company in Russia. That's everything for the time being. Best wishes and goodbye.